Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have the exceptional attorney, Kevin Estevez, who is going to give us an incredible webinar on a contractor, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce Kevin Estevez.
Thank you, Ariella. Good morning, everybody. Like Ariella said, we're going to talk today about contractors, subcontractors, and suppliers, the steps they need to take to get paid on a construction project. So with that, let's jump right in. So if you have any questions during today's webinar, please use the chat box on the right. We'll hold off on answering any questions to the end, and please do not include the names, your names or the names of your companies in the question. So in Arizona, contractors and suppliers have numerous remedies available to them in the event they're not paid on a construction project. Two of the most effective, which we're going to cover in depth today, are mechanics liens and payment bond claims. And as you'll see in step number 1 that we'll cover, in most situations, contractors and suppliers must timely serve a proper preliminary 20-day notice to preserve mechanics liens and payment bond claims. But lien claims and bond claims aren't the only remedies that contractors have. They're also afforded substantial protections under Arizona's Prompt Pay Act. And in addition to that, there are other additional remedies they have. One being, the claims for breach of contract in a typical civil lawsuit. But the Arizona Registrar of Contractors also affords some remedies to contractor or subcontractors and suppliers to assert non-payment claims there. Next slide, please. So the first step in preserving or preserving your rights to get paid is serving a preliminary 20-day notice. And if you've listened to any of these webinars in the past, this is something that we often stress, and it is step number 1 for a reason. And that's because except for laborers for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work on a project. If you don't serve a 20-day notice, you forfeit all lien rights. If you don't serve a timely 20-day notice, you forfeit a portion of your lien rights. And the way preliminary 20-day notices work in Arizona is they catch back 20 days. So if a project starts on March 1st, as long as the contractor, subcontractor, or supplier who's furnishing material within those first few days serves a 20-day notice by March 20th, everything from March 1st going forward will be covered. If, for instance, they wait till, say, March 30th to serve a preliminary 20-day notice, well, the notice catches back 20 days to March 10th, and so everything from March 10th going forward would be covered. But that time period between March 1st and March 10th would not be covered. So the labor and materials furnished during that time period, the claimant would not have lien rights for those. So it's important to give your 20-day notices early and promptly. And as we'll talk about in a little bit, it's also important to supplement those as need be. The purpose of the 20-day notice is to let the owners know who's on their project working and who expects to be paid. Next slide, please. Contents of a preliminary 20-day notice pursuant to ARS 33-992-01C. It should have a description of the labor or materials that would be furnished and an estimate of the total price, the name and address of the person furnishing the labor and materials, the name of the person who contracted for the purchase of those labor and materials, an adequate description of the job site for identification, and a specific statutory notice to property owner that is prescribed by ARS 33-992-01C5. 33-992-01D includes a sample preliminary 20-day notice, which contractors must substantially follow. Okay, the preliminary 20-day notice must be served on the owner or reputed owner, the original contractor or reputed contractor, the construction lender or reputed construction lender, and the person with whom the claimant contracted. They should be addressed to the recipients at the residence or business address and served via either first-class mail with a certificate of mailing, registered or certified mail with postage prepaid. Again, the idea of 20-day notice is to let those folks upstream, especially the owner, know who is working on their project and who expects to be paid. 20-day notices are deemed served when they're deposited in the mail. So we talked about a short time ago, you should serve your 20-day notices promptly upon starting work on a project, but in any event, you don't want to serve it later than 20 days after you start work. And I already talked about this, where you have the situation of the notice catching back 20 days. So if you don't timely serve a 20-day notice, you don't forfeit all of your lien rights if you go ahead and serve one, but you forfeit a portion of your lien rights potentially. If you don't serve a 20-day notice at all, you forfeit those lien rights. And again, mechanics liens are one of the most effective methods of getting paid as a contractor, subcontractor, or supplier on a construction project. All right, step 2 on steps you need to take to get paid as a contractor, supplier, or subcontractor in Arizona is know your rights under Arizona's prompt pay laws. And Arizona has both private sector and public sector prompt pay laws. The public sector prompt pay laws are set forth in ARS 286924, which governs ADOT projects, ARS 412577, state projects, and ARS 34221, which covers city, county improvement district projects. And these govern public, like I said, public projects. The private sector prompt pay laws are governed by ARS 321181 et sec, and these apply to private projects that last 60 or more days with the following exception. They only apply to residential, which is better defined pursuant to the statute as owner-occupant projects if the contract with or invoices to the owner-occupant contain a notice that the prompt pay laws will apply, and the parties can, as a matter of law, alter the billing cycle that we're going to get into under Arizona's prompt pay laws by, number one, providing a different payment schedule in the prime contract in a clear and conspicuous manner, and placing a statutory notice of alternate billing cycle on every page of the construction bid and plans. And you may ask yourself, well, why does this notice have to be on every page of the bid and plans? And that's because that notice is designed to allow folks downstream on a construction project who may not always see the prime contract to know that this project is governed by a alternate billing cycle that deviates from Arizona's prompt pay laws. And because the hassle you have to go through to alter the billing cycle on construction projects, it's almost never done in Arizona. So a good bet is if you're working on a commercial project, it is going to be governed by Arizona prompt pay law. The standard billing cycle on public and private projects vary a little bit. They are both set up so the contractors get paid, so the billing cycle is a 30-day billing cycle, but the timing mechanisms are a little bit different. And those timing mechanisms vary with respect to the time the owner has to review and then pay approved payment application. So on public projects, as you can see from the slide here, the owner receives a general contractor's invoice, and then it has 7 days to review and approve it or object in writing, and then 14 days to pay. Once the owner pays the general contractor, then the general contractor has 7 days to pay the subs, and then once the subs receive payment, they have 7 days to pay their material suppliers. On private projects, you can see what changes is the time that the owner has to review and approve the payment application. So on a private project, the owner has 14 days after receipt of a general contractor's payment application to review and approve that payment application. And then they have 7 days to make payment. And then after that, the public sector and the prompt pay sector, the public sector and private sector prompt pay laws don't have any differences, meaning that once the general contractor receives the payment from the owner, then they have 7 days to pay the subs. And once the subs receive the payment from the general contractor, they have 7 days to pay their suppliers. So this next slide here shows the key features of the private sector prompt pay laws in Arizona. Like I mentioned before, the laws set up a 30-day billing cycle. Owner has 14 days to approve, 7 days to pay once they receive a payment application. And then the subcontractors and suppliers pay within 7 days of receiving payment. If an owner would like to object to a payment application or they feel the funds aren't owned, they have that 14 days and they must object in writing. And that's a key feature. And then in addition to that, under the prompt pay laws, if we could go back to the previous slide. One of the key features of the prompt pay laws is they allow contractors and subcontractors as a matter of law to suspend or terminate performance on a contract if they're not timely paid and if they provide sufficient written notice to the upstream parties. And the prompt pay statutes sufficiently detail the specific types of notice that contractors and suppliers have to give and the timing within which they have to give that notice if they're going to suspend work on a project. Lastly, the prompt pay statutes afford contractors, subcontractors, and suppliers interest at 18% annum on past due amounts that are not timely paid. Step 3 on our steps to make sure that you get paid as a contractor, supplier, or subcontractor is to ensure that you supplement your 20-day notice if it's necessary. As we said earlier, 20-day notices are required to contain an estimate of the total price of the labor and materials to be furnished on the project. And your lien rights are limited to 130% of the estimate amount in the 20-day notice. If the contract is increased beyond this limit, the 20-day notice should be supplemented. And it should be supplemented within 20 days of furnishing the additional labor and materials. And one thing is important here is to make sure that the supplemental notice sets forth a new estimated total price. We don't want to have piecemeal supplementations, which we see on a regular basis. So if the original contract is for $100,000, let's say, and the contract is increased via a change order to $140,000, then that's above the 130% threshold, which would require a supplemental notice, and we'd want the estimated total price in that supplemental notice to be $140,000, not $40,000, which would be the result of just the increase. We want the supplemental notice to include the full aggregate price of all the labor and materials that are going to be furnished to the project. Step 4, know your deadline to record a mechanics liens or bond claim on a project. On private projects, mechanics liens assert an ownership interest in the real estate on the grounds that the claimant provided services or materials to improve that property but hasn't been paid. Liens can't be recorded on public property. An owner-occupied resident cannot be liened unless the contractor or supplier has a direct contract with an owner. Residential owner-occupants, that's a carve-out potentially on lien claims. And then another carve-out is a project is being built for a tenant. The contractor or supplier may only have lien rights against tenant improvements. And those are rather specific situations that you'll want to consult a lawyer with directly if you run into those situations, because they are more technical than lien and bond claims already are. But because public property cannot be liened, federal and state law requires payment bonds on projects of a certain type and size. And then in those circumstances, qualified subcontractors and materialmen may have claims against the bond if they satisfy certain notice requirements. With respect to mechanics liens, a mechanics lien must generally be recorded within 120 days after project completion. Completion pursuant to Arizona statutes it varies depending on the type of project. On projects where a certificate of occupancy is issued, completion occurs 30 days after that certificate of occupancy is issued. So in that circumstance, you'd have 150 days after the certificate of occupancy to record your mechanics lien. If no certificate of occupancy will be issued, then completion occurs on the last day labor or materials are furnished. If the work stops, if labor is ceased, and before the work is completed, and the completion will be 60 days after the work is stopped. And so in that circumstance, you'd have a total of 120 days, or 180 days, 120 days after project completion, and project completion being 60 days after the stoppage. And again, one thing to remember, and it's a little bit different than bond claims, is with respect to liens, the lien deadlines are measured from the completion of the project for all contractors. So if you are a subcontractor or material supplier that furnishes labor and materials early on in the project, your lien rights and your lien timing is governed by the completion of the entire project, not measured from when you last furnished labor or materials. The one way that owners can cut short the deadline for recording mechanics liens is to record a notice of completion, and that sets forth, or that accelerates the deadline for recording a mechanics liens to 60 days after the notice is recorded. But the owner must provide a copy of the notice of completion to every person who served a preliminary 20-day notice on the project as well. So they need to record it and they need to provide notice, and that is a way that the time to record a lien can be truncated in Arizona. So when you've recorded your lien, what happens next? You must serve the notice of claim of lien in order to keep your lien rights preserved. And you must serve the notice of claim and lien within a reasonable time of recording. And then for purposes of the statute, the term serve requires that service be made by mail, first-class mail, registered or certified mail, with sender obtaining a certificate of mailing. But service can also be made in the same manner that process is served in Arizona. So you can serve a lien via the mail methods specifically identified in this slide, or you may serve it in the same manner that process is served in Arizona. The phrase "a reasonable time after recording" is not defined in Arizona law, but as a general matter, you want to get the notice and claim of lien served as promptly as possible, ideally right after it's recorded. Next slide, please. So payment bond claims on public projects are a little bit different in terms of the timing mechanisms. So on federal projects, laborers and materialmen with no direct relationship to the general contractor furnishing the payment bond. And that's an important thing to note here, is that the payment bond will be furnished by the general contractor, must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last of materials for which the claim is made. So this is that distinction we talked about a short time ago. On payment bond claims, the timing mechanism kicks in after you, as the subcontractor or supplier, last furnished labor or materials, not from when the project is complete. In Arizona, a claimant who has a direct contractual relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship expressed or implied with the contractor, has a right of action on the payment bond upon giving the contractor the following notices. 1, a preliminary 20-day notice that we already talked about earlier, and 2, a written 90-day notice given within 90 days after the claimant last performed work or furnished materials, stating the A, amount claimed, and B, the party to or for whom the material was supplied or the labor was performed. So here's a slide that is a graph of this concept and the notice requirements on Federal Miller Act and Arizona Little Miller Act bond claims. You can see the general contractor as the party that's furnishing the bond is up top, and the first tier subcontractor are protected, and so is the first tier supplier. So the folks that have direct contractual relationships are protected, and they don't have to provide notice because theoretically the general contractor knows who they contract with, and so there's no notice requirements for those first tier subcontractors and suppliers. The second tier subcontractors and suppliers are protected, and those are the folks that are below that first tier subcontractor here, but they must provide the notices that we just talked about in the previous slide, and if they don't provide those notices, they forfeit their bond claims. And then further on down, the folks here in the red, the third tier subcontractor, the third tier supplier, and the second tier supplier are not protected under the payment bond claims. Step 5, know your deadline to file suit to foreclose on the lien or recover against the bond. A claimant must sue to foreclose its lien within 6 months of the lien being recorded. What a foreclosure suit does, it asks the court to order the sale of the property to satisfy the lien, and then claimants with valid mechanics liens share the proceeds. If no foreclosure action is filed within 6 months, the lien expires by operation of law. Conversely, payment bond claimants, they must wait 90 days after they last furnish labor and materials to the project, and a Miller Act claimant or an Arizona Little Miller Act claimant, after waiting that 90 days, may bring a lawsuit to recover on the bond. And the statute of limitations for suit on a bond claim expires 1 year after the date the claimant last performed labor or materials. So mechanics liens, you have 6 months to foreclose. Bring suit to foreclose on your lien. Payment bond claims, you have a year after you last furnish materials to sue to recover on the bond. And then I talked about ROC remedies that contractors or subcontractors and suppliers have in Arizona. You have 2 years after you furnish labor and materials, or the event giving rise to the claim, to make a claim with the ROC. And then you have 6 years to sue generally on a breach of contract claim in Arizona, and that is governed by the notice requirements. So 6 years from the notice of a breach on a written contract to sue in Arizona. And so those are the steps that we have to cover to recover as a contractor, a supplier, or a general contractor on claims in Arizona. Again, as we alluded to during the course of the presentation, claims in Arizona with respect to mechanics liens and and payment bonds are highly technical. They're some of the most technical legal claims that can be asserted. So this webinar does not provide, it should not be used as legal advice to any specific situation. And I would encourage you all to, if you are in a circumstance where you have a lien claim, a bond claim, or are seeking some other mechanism to get paid on a construction project, that you consult with a qualified attorney. And so with that, if anyone has any questions, please let us know. Be happy to answer them. And I don't think we have any questions. So our next webinar will be Tuesday, May 23rd, 2023, and that's going to cover what happens after I record my lien, how do I get paid, and we'll dive into some more of the topics I touched on briefly today. And then on Tuesday, August 22nd, 2023, we're going to cover lien waivers and why you should be especially careful before you sign lien waivers as a contractor or a supplier in Arizona. And that concludes our webinar for this morning. I'd like to thank
Hear me? I
everybody.
want to say thank you so much for